Maybe.
Yes.
Lordship, I beg to mention item number 13, Lordship, therefore withdraw, Lordship.
1-3.
1-3.
Why do you want to withdraw?
Already compliance, Lord. Authority has
I
already
see.
compliant. My business.
You are Mr. M. Saikia.
M cycle.
Mr. M. Saikia, learned counsel for the petitioner submits that the order of this court has been complied with. And therefore, the petitioner no longer wishes to press the matter. In view of above, contempt petition stands closed.
We have got a 1 and 4
Keep
for the respondent.
Okay. Mr. SNTG Steel, learned counsel, appears for respondent numbers
1 and 4.
1 and 4.
May it please, Your Lordship.
Yes.
I beg to mention item number 3, Lordship. Meta may have done for the day, Lordship. It may come on Friday, Lordship.
Date we're not giving after a week.
Lordship. Next Monday, Lordship.
No, registry will give you a date. As paid for by the learned counsel for the petition, the matter stands adjourned. To be listed again after a week on a date to be fixed by the registry.
Lordship, next week. Lordship.
May I please go?
Lordship,
I beg to mention for listing two writ petition for admission, Your Lordship. On next week, because Your Lordship, in one matter, Your Lordship, what happened, I'm for the respondent and petitioner, although he has not participated in the selection process, Your Lordship, he filed the writ petition and notice has been issued.
You approach the registry, okay?
On next week, Your Lordship, and
You approach the registry for next week, they'll give you. There's a register, just enter it.
I may be allowed to put a date on next week, Your Lordship. On the
Please
mention
go there, enter in the register, they'll give you a date.
oblige.
All right.
Yeah, please, Your Lordship. My lord, item number 1, my lord, there is some development, my lord, as per instruction of calendar also. So I pay for on next week. That I will talk about.
Development, what kind of development?
Lord, a complete instruction not issued, Lordship. So I pay for next week. Lordship.
No, you are also required to examine whether contempt petitioner will lie or not also.
Lordship, there is also.
Please examine that aspect.
Next week.
As paid for by the learned counsel for the petitioner, matter stands adjourned for a week. To be listed again on a date to be fixed by registry.
Deeply obliged.
This matter, the Lordship, basically there was a direction from this honorable court on the earlier round of litigation. Then your Lordship, on the last two occasions, this honorable court has directed them to produce the instructions along with the decision, what decision has been taken in the hearing that has been conducted. Your Lordship will kindly see the orders passed by this court on the last two occasions. And instructions are to be placed.
Some hearing was conducted.
Yes, hearing was conducted. They were directed to be considered by the committee, and the committee hearing, they were also called for the hearing. Hearing was done. Thereafter, nothing was done. Then we came before this honorable court. So now the court has directed that the instructions should be placed, where what happened in the hearing and what final decision has been taken. The
Who's to get the instructions?
It's a
BTC.
BTC is supposed to get the instruction. And the order that was passed was long back, Your Lordship. In fact, that judgment of this honorable court was, it starts from page 38 here. Just before he comes, I'm just referring.
Yes.
Page 38, it starts. The relevant paragraph is at page 44.
How many petitioners are here?
Here, Your Lordship, in this matter, I think 9 or 10. There are we are 10 petitions.
10 petitioners. Earlier 16 petitioners.
Earlier 16, those 16, 6 of them, Your Lordship, either they left or what has happened.
Then what was the
Then
grievance?
the order at page 44,
What was the grievance?
the grievance is that they were working and the similarly situated persons have already been regularized in the service. They have not been regularized. And that is why this honorable court at page 44 stated, bearing in mind the unacceptable reason for rejection.
Yes, the PNAC will appear, they have instruction, Lordship. We can take it after some time, Lordship. He is yet to.
Yes, tell us, Mr. Manan. Mr. Manan.
Yes.
So what was the order?
The order, Your Lordship, I'll just refer to the relevant portion, that is at page 44 here.
Yes.
para 14. Just para 14, that's all.
Yes.
Bearing in mind the unacceptable reason for rejection of the regularization claim as communicated under the impugned order dated so and so. I feel that the rejection decisions should be revisited by the BTC authorities. Thus, in the impugned order dated so and so, containing the decision of the BTC Executive Council recorded on so and so is set aside and quashed. Consequential direction is thus issued to the authorities to redecide the claim for regularization of the left out group of teachers appointed in so and so. However, it is made clear that the fresh consideration will only be for those who are still in the fray, and the petitioners who have abandoned the litigation cannot claim reconsideration. To facilitate the exercise, the petitioners in both cases should file representations before the Director of Education, and the officers should ensure reconsideration by the competent authority, who should revisit the decision taken by the Executive Council on so and so. It is ordered accordingly.
Okay.
So the whole issue they have initially rejected. The rejection was set aside by the Honorable Court and directed them to revisit. For the revisit part, Your Lordship, in the meanwhile, Your Lordship, they have also, the petitioners have also completed their BLED. I have annexed those documents from page 46 onwards. I am not referring to those. Then Your Lordship will see at page 51. 17 of these petitioners were called, Your Lordship. 17 were called by this letter, wherein Your Lordship for hearing.
Lordship, may I serve it? What are the complaint?
Just understanding the background.
Yeah.
I'm sorry, Lordship, I'm disturbing.
Just
Lordship, in this matter, I have already received my instruction, Lordship, and my affidavit is, preparation of my affidavit is going on, Lordship. So I'm praying for just 2 weeks' time, Lordship. In the meantime, I'll file my affidavit.
Okay, notice has not gone, isn't it?
notice
Otherwise,
not gone. in.
will issue notice, then you file a
Lord.
affidavit.
Lordship.
Mr. Manan,
Lordship.
heard Mr. Y.S. Manan, learned counsel for the petitioners. Issue notice of motion returnable by 2 weeks. Mr. P. Nayak, learned standing counsel BTC, appears for respondent numbers.
Me পইচা হ'ব মোৰ problem নাই আহি তেওঁ পাতি আছে কাৰণে মই দুটাই কৈ আছে He appeared
3,
for
4, 5,
3, 4,
And five.
and
5,
6.
6. 3, 4,
5,
5 and
3, 4, 5, and 6. And elementary
and-
will appear.
1 and 2 by my.
Mr. SM T. learned standing counsel, elementary education, accepts notice on behalf of respondent numbers 1 and 2. Stop notice is complete. Stop Mr. P. Nayak, learned counsel, submits that he has received instructions in the matter and he will be filing the affidavit within 2 weeks from today. In view of above, list this matter again after 2 weeks on a date to be fixed by the registry. Petitioners shall furnish requisite copies of the writ petition to the learned counsels equivalent respondent
That will
today
furnish.
within 2 days.
Lordship will fix a date.
They'll fix a date. 2 weeks, they'll fix a date.
Much okay.
Pleasure lordship. Matter relates to compassionate appointment lordship. Petitioner approached earlier. Page 21 lordship.
What was the direction?
Page 22 to 11 page,
Yes,
para 5 lordship.
please read.
In view of the proposition of law laid down by the Honorable Supreme Court in Syed Kadim Hussain Supra, the stand taken by the respondent authorities in not placing the application of the petitioner before the DLC is not sustainable in law. Accordingly, the district limited education officer Nalbari is directed to place the application of the petitioner for compassionate appointment dated 11/4/2022 before the next available DLC of Nalbari district for a consideration in terms of law laid down by the Honorable Supreme Court in Syed Kadim Hussain Supra. Thereafter, my lord, page 31, petitioner recommended for grade 4 post. ELC recommended, lordship. page 31, last para. May I read, Lordship?
Yes, we,
So considering the above and considering the Honorable High Court order dated 12/12/2023 in respect of WBC number so the DLC has decided to recommend the proposal of Sri Shahjahan Ahmed, that is petitioner, Lordship. So now let Zainur Ahmed against 34 nong of current vacancy of grade 4 post under Education Department, the office of the District Elementary Education Officer Nalbari and office of the Inspector of School NDC Nalbari District. Thereafter, page 32, Lordship, the DLC forwarded the minutes of the meeting to the Joint Secretary to the Government of Assam, Department of School Education, Lordship. In the meantime, Lordship, OM has come. A matter is pending before SLC for consideration.
yes,
Lordship, it is pending before the SLC. We had already forwarded our letter, Lordship, page 32 already mentioned.
so we direct the SLC to consider that.
Yes, Lordship.
But Mr. N. Hussain,
Mm.
learned counsel for the petitioner, who submits that the petitioner earlier approached this court by filing WPC number 6402 of 2023. Seeking consideration or compassionate appointment by the district level committee bracket DLC Nalbari. Stop the writ petition was disposed of by order dated 12/12/2023 by directing the respondent authorities concerned to place the case of the petitioner before the DLC Nalbari. So consequently, the case of the petitioner was taken up by the DLC, which met on 28/8/2024. And he was recommended against the vacancy in grade 4 post under the establishment of District Elementary Education Officer Nalbari. To stop the DLC minutes was sent to the Joint Secretary to the Government of Assam School Education Department by the Additional District Commissioner Nalbari on 30/9/2024. But however, the case of the petitioner has not been considered by the state level committee till date. And therefore, the petition is before this court. Stop the learned counsel submits that in the meantime, an office memorandum dated 18/9/2024 came to be issued by the Government of Assam in the personnel bracket B department. By which it was provided that the compassionate appointment scheme has been discontinued in view of the introduction of compassionate family pension scheme. Stop the learned counsel, however, submits that a number of persons similarly situated as the petitioner approached this court, and this court, by common order, dated 3/4/2025. And the lead case being WPC number 342 of 2025. Directed that all the pending cases for compassionate appointment be considered by the respondent authorities in terms of the relevant guidelines formulated by the government. The learned counsel therefore submits that in the case of the present petitioner also being covered, a similar direction may be issued. Of Miss A. Kuwar,
S four.
S. Kuwar, Learned Standing Counsel, School Education.
Common advocate.
I'm sorry, S. Kuwar, Learned Government Advocate, submits that insofar as the district level committee is concerned, same has already been, no, right like this, insofar as the DLC is concerned, they have already recommended the petitioner and the matter is pending consideration before the SLC. She submits that in view of the earlier orders passed by this court in a similar case, court may pass appropriate orders as it deems fit and proper. Stop next parent view above. Having regard to the fact that the petitioner's case is also covered by the earlier decision of this court, earlier order of this court, the writ petition is disposed of by directing the respondents to place the case of the petitioner before the next SLC for considering his case for compassionate appointment. Since the DLC recommendation had been forwarded to the Joint Secretary to the Government of Assam School Education Department. And not required, since from that we cut off this poster.
Unless
I think 5, 11 and 12 were same. And the pursuant to a notice, the lordship will kindly see page, recruitment notice at page 37. The petitioner was appointed, 3 petitioners were appointed as office assistant and grade 4. Now, they are working at a very low salary. Page 37, fixed pay only they were appointed.
What is the appointment against which post?
Office assistant and grade 4.
Grade 3 and grade 4.
Yes, ma'am. Petition number 1, 2 and 3, office assistant and others are grade 4. They were appointed, my lord. Now the grievance is, my lord, 2 grievance, my lord. They have sent proposal for regularization of their service to the authority. They are sitting over the matter. That your lordship will get it at page 56. Page 56, this is a letter written to the Director Higher Education by the registrar of the university. And the post are, your lordship can see the post at page 58.
Where are they appointed?
They were appointed in the year 2017, man.
Borderline University.
18, yes,
Borderline University.
yes.
So,
And now they have, this is one problem, they are sitting over the matter. They will have to take a regularization method. You may have to advertise and all, but the proposal has been sent to the government. They are sitting over the matter. Your lordship will kindly see the last line of the petition, page 57. The copy of the shortlisted post along with the financial involvement is enclosed for your ready reference. It is quite mentionable that the additional fund will not be required for the current financial year 2023-24. Yet, my lord, government is sitting over the matter. This is one aspect of the matter. The other aspect of the matter is, my lord, they are serving equal the regulars like a regular, my lord, employees. Regular employees are getting much higher pay, but they are getting much lower. So I pray, my lord, your lordship may issue notice at this stage, fixing a date. And my lord, I have annexed 3 judgments also, showing, my lord, if one is discharging similar work, then they are entitled to get equal pay.
okay, we'll issue notice
My
now.
lord, at this
But-
stage, notice. my lord.
Right, Mr. B.D. Das, Leonard Senior Counsel, assisted by Mr.
HR.
H.R. Das. For the petitioners, who submits that the petitioners were selected to grade 3 and grade 4 posts on the basis of selection conducted
That is great treat.
by the respondent authorities. In the Boroland University in Kokrajhar. And they have been working as such ever since their appointment in the year 2018. On a fixed pay. Stop, although the
They are serving like a regular employee.
university authority has made a proposal to the Director of Higher Education, Assam, for creation of posts in the university. So that the petitioners and other similar situated persons can be considered. For appointment in a scale pay in a regular post. But the respondent authority concerned has not taken any steps. Stop. He submits that the petitioners, in fact, are performing similar nature of work as that of a regular employee. And therefore, their right to enjoy equal pay for equal work has been grossly affected. Next, in view of above, issue notice of motion returnable by 4 weeks.
I'm for 1 in 3 losses, as we are, sending a higher division losses.
Mr. S. Bhuyan, Learned Standing Council, Higher Education,
1 in 3 losses.
accepts notice on behalf of respondent numbers 1 and 3. Stop, Mr. S. R. Rabha,
Paying for reference number 4.
Learned Standing Council, EDC accepts notice on behalf of respondent number 4. Stop, petitioner to take steps.
Finance is also.
Finance 2.
Who will be there, finance?
Google. Not too good.
Solia,
Mr. A. Saliha, Learned Standing Council, Finance accepts notice on behalf of respondent number 2.
2.
Stop, petitioner to take steps for service of notice upon respondent numbers 5, 6, and 7 by registered post with AD2 within 3 days. List the matter again after 4 weeks on a date to be fixed by the registry.
And the pendency shall not be a bar for consideration of their representation. The
There's a representation.
Representations are there. 3 representations are there. It should not be a bar, my lord,
Okay.
otherwise.
It is also provided herein that pendency of this writ petition shall not be a bar for the respondents to consider the pending representation of the petitioners.
Now, others are also, item number
Consider
11,
and dispose of the pending representations.
item number 11 is also saying, my lord.
3 and 4, grade 3 and 4.
Grade 3 and 4.
It's a unique tree.
The
Okay.
item 11 is only grade 3.
Item 11 only grade 3, no 4.
Item 12 is only grade 4.
Item 12 is grade 4 only.
Grade.
Okay, and what about the position of the respondents? It's similar.
Similar.
Okay.
Deeply only.
May I take your question? Lord, it is a similar matter on, like this on Monday, I have moved Milord already. The matter earlier they approached this matter honorable court. The honorable court was directed to place the matter before the state level scrutiny committee. State level committee Milord rejected their claim on the ground that the minutes or resolution of the Milord DSC is not available.
A similar matter has already been tagged it may tagged your lordship with petition number, sub number.
What, has it been disposed?
No,
No, your lordship,
Notice of-
4333-2025.
Notice was issued.
Tagged along with the petition 4333-2025. Similar matter.
This is also second round.
Yes, second. There is order at page 39 below. The name of the prisoner at serial number 1. Prasenjit Roy.
This is sorry, no?
Only one petitioner is.
Only one prisoner.
Notice we said. We did.
And the direction of this honorable court, page 44. Page 44.
Then what happened after that?
Then it was placed before the state exploratory committee, then it was rejected by the order dated 22, that is page 46 and extra 10.
It was rejected.
Rejected on the ground that the minutes or resolution of the district exploratory was not
47.
available.
Reflected
Okay, now,
to non-availability of the resolution.
then where is the scrutiny?
Yes, page 25 Name of the petitioner at serial number 2 column number 9, serial number 2, Shri Prasenjit Roy.
Prasenjit Roy.
Prasenjit Roy. Yes, 25.
What is the date of the,
Actually, in the recommendation, there was no date. They send through a letter. It is a recommendation of the.
why do they sign without dates? Must be very old, I think. 10 years back. There's no date, so we don't know when it was signed. Anyway, heard Mr. P.A. Qayyum, learned counsel for the petitioner, who submits that this is the second time the petitioner is before this court. Stop the earlier writ petition being WPC number 399 of 2024 was disposed of by order dated 29/1/2024 by directing the respondent authorities to place the name of the petitioner, name of the petitioners, including the instant petitioner, before the state level scrutiny committee within a time frame for consideration. This is provincialization for provincialization of service. So however, when the matter was placed before the committee concerned, the case of the petitioner came to be rejected by order dated 20/2/2025. Bracket annexure 10. Stop. Aggrieved, the petition is again before this court. Stop. The learned counsel submits that the state level scrutiny committee could not have rejected his case for want of resolution of the district scrutiny committee, in view of the fact that the district scrutiny committee had recommended his name for provincialization. Stop. In this connection, the learned counsel has drawn attention of this court to annexure 3 of the writ petition, which is the recommendation made by the district scrutiny committee, Dhubri. Wherein the name of the petitioner is at serial number 2. Next, para in view of above, the issue notice of motion. Turnable by 4 weeks. Speed Das, Learned Standing Council, Secondary Education. Accepts notice on behalf of respondent numbers
1, 3, and 4.
1, 3, and 4. Who else is there? Miss R.M. Barua, Learned Standing Council Finance Department, accepts notice on behalf of respondent number 2. Stop. Notice is therefore complete. Petitioner shall serve requisite copies of the writ petition to the learned councils appearing for the respondents today within 2 days. This is the matter again after
Copy to the. Hard copies, soft copy to the.
4 weeks on a date to be fixed by the registry. You want it to be tagged with this matter along with WPC number 4333/2025.
I'm deeply obliged.
May I please, Lordship? Lordship, this matter is regarding promotion of grade 4 employee to grade 3, Lordship. Lordship, similar order was passed by this Honorable High Court. Lordship may come to page number 36. That this case was disposed of. Page number 36, Lordship.
Relevant pursuit what?
Yes, so how do you say your case is similar?
Lordship, earlier on this case, the petitioner was same grade 4 employee and he was promoted to grade 3 employee. And in this petition, similar that is, petitioner is a grade 4 employee. He was continuing his service from 2013. He has completed 12 years of his service.
So what is the provision for promotion to grade 3? Under what provision?
Under Rule 5, Clause 2, Lordship.
Show me that rule. Where is it?
In the education manual, Lordship.
Annex 4.
What is the eligibility criteria?
Eligibility criteria, he was qualified. He was graduate person, Lordship.
Simply saying qualified will not do. You have to tell me how many years of service and what kind of qualifications required.
Lordship, annexure 26-27. Mark sheet and pass certificate of graduation.
That will not do.
Yeah.
Show me the provision.
Provision of work.
Simply because you're working for 20 years, you say you cannot be promoted like that. There has to be a provision.
Provision is here, Lordship.
Show me.
Page number 26 of education manual.
You should abstract that in your writ petition also.
relevant part
Page 26.
Yes, Lordship, page 26.
Yes, rule, which rule?
Rule 5, clause 2.
Please read.
5% of the total post of junior assistant of a district shall be filled up by the direct recruitment from the candidates amongst the grade 4 staff of the schools under the concerned district having requisite qualification with 5 years experience of continuous service as grade 4, and remaining posts shall be filled up by the direct recruitment from the open competition.
Junior assistant.
Yes, Lordship.
You're working since 2013.
13.
Now, any vacancies there?
Yes, Lordship. Earlier also,
Any
Ye-
process?
petitioner filed a writ petition, and on that order,
Where is that order?
Lord, page number 25. That post shall be remain vacant. That order was passed. Page number 25, Lordship.
What happened to this writ petition?
Still it is vacant, Lordship.
Then one writ petition is still, your lordship,
That was disposed of, Lordship.
Still it is vacant, you're saying. We're talking about the writ petition. Is it still pending or disposed?
Disposed of.
When?
It was disposed of on 2020.
Where's the order?
Yes, it is page number 32, Lordship. Thirty-one. Rule 5, clause 2 was discussed in this order, Lordship. Come to the page number.
The order is already there. What more do you want?
He may be promoted, Lordship.
How?
On basis of this rule, Rule 5, clause 2, it was also.
So there are many factors, you see. You cannot just automatically be provided. Rule is there, I should be promoted. Cannot be like that. What is the vacancy position?
Yes.
See, you have already come before the court. Again, you cannot come like that for the same thing. You have to pursue with this.
He made one representation along with this earlier, your lordship judgment, and he should go there, your lordship. Along with the representation and this order, 1449/2020, which is passed on 2011-2020. First, he should communicate, your lordship, along with this, your lordship, order copy, earlier order copy. If that representation is not accepted by the concerned department, then they should make one case, your lordship.
He was communicated.
When was it?
Where is the communication later? Representation is not annexed here.
See, you're repeating the same prayer again. Court has already passed an order saying that consider his case also. You are to approach the respondent authorities saying that this is the order, please consider me. And also find out whether there's any vacancy where you can be considered. Then only court can step in. You have to help yourself, you see. We cannot take you there and say, go and sit here, this is your post. You have to help. there's a vacancy here. I've given the order. There's 5% reservation there as per the rules. I should be considered, I'm the senior most. All those things are there, you see.
The vacancy was there. There is no any employees working on that grade 3. Vacancy was there.
If vacancies, then you approach the authority. By which letter have you approached?
That
Again,
represent-
you're simply filing writ petition like that. Will direct you to approach.
Yes, Lordship,
Heard Miss
the Angana.
P. Talukdar,
Angana, cause list, my name is Soini.
Miss Angana Das,
Yes, Lordship.
learned counsel for the petitioner, and Miss P. Das, learned standing counsel, secondary education. Start arguing regard to the nature of the grievance projected by the petitioner, the writ petition is taken up for disposal at this stage. Stop. It is seen that the petitioner has come before this court for the second time. Stop. The earlier writ petition being WPC number 1449 of 2020 was disposed of by order dated 2011-2020 by directing the respondents to consider the case of the petitioner against vacant posts, against vacant grade 3 post,
Grade
correct?
3.
In Champarmukh BBHHS school. In terms of Rule 5 bracket 2 of the Assam Secondary Education open bracket provincialized schools close bracket rules, 2018. Wherein there is a reservation of 5% of the total post of junior assistant for grade 4 staffs having the requisite years of service. So the learned counsel submits that although there is vacancy in the grade 3 posts, the petitioner has not been considered and therefore he is again before this court. To stop. On being asked as to whether the petitioner had approached the respondent authorities for considering his case after the disposal of the writ petition on 2011-2020. The learned counsel submits that the petitioner had indeed approached, but he has not been considered. To stop. However, there are no communications or representation submitted by the petitioner communicating the order of this court. And therefore, this writ petition is disposed of by giving liberty to the petitioner to approach the respondent authorities with appropriate application by enclosing a copy of the order dated 2011-2020, passed in WPC number 1449 of 2020, along with a copy of this order. For consideration of his case against the available vacancy in the grade 3 post in accordance with the relevant rules. Stop.
I'm deeply obliged.
May I please, Your Lordship? My lord, the petitioners here, my lord, are the retired teachers, one. And my lord.
What teachers?
Retired teachers. one.
Retired teachers.
Retired. Now, my lord, the petition number 1, my lord, was given the leave encashment benefit of 230 days. And petitioner number 2, my lord, has been given the benefit of leave encashment for 227 days, my lord, instead of 300 days, my lord, to which they are entitled, my lord. Now, my lord, this is a covered case, my lord. Your lordship will find, my lord, at page 47, my lord. That is relevant, my lord. This court, my lord, has passed, my lord, so many orders, my lord. One of them, my lord, I have managed to. 46, my lord. And relevant, my lord, page 47. Below, my lord, having regard to the above, my lord. So they will verify, my lord, and they will pay, my lord, as to how many days I am entitled to. If verification may be required.
Where do you get this 300 days? Any provision?
Provision, my lord, page, my lord, 42, kindly see, in terms of this notification, my lord. Earlier, my lord, there was a distinction between the employees of, my lord, a vacation department and non-vacation department, but that has been removed by this notification. Page 42, my lord, 42 to 45.
Vacation department, what do you mean by vacation department?
Vacation department, my lord, there is vacation, they enjoy vacation. Supposing, my lord, summer vacation, puja vacation,
Oh, vacation, understand, but vacation department.
department. School, my lord, it is identified as vacation department. Teachers. So that has been removed, my lord. That difficulty is removed by page 42, 45, my lord, kindly see. Page 42, my lord, typed copy, my lord.
But where is that 300 days?
300 days, my lord, page 25, my lord. Twenty-four relevant, my lord. 23 and 24, my lord.
On leave.
24, my lord, relevant. The existing maximum limit of 240 days. It was earlier 240 days. On accumulation of earned leave provided under Rule 9(1)(b) of the revised leave rule 1934 shall be enhanced to 300 days. As a whole, it was, my lord, made to 300 days. Again, my lord, it has
You're-
been
You are claiming on the basis of this office memorandum.
office memorandum dated, my lord.
Then why are they not giving you? They also should calculate it as per this OM only.
Yes, my lord. They should have calculated, but
What
did
is
not
the,
calculate properly, perhaps, my lord. And therefore, my lord, large number of litigants, my lord, used to, my lord, they approach before this honorable court at some point of time. Now they have, my lord, increased, enhanced. Earlier, my lord, it was given only for 80 days, 90 days, and therefore so many litigants approached, my lord. Now, all employees, my lord, irrespective of the fact whether they belong to vacation department, non-vacation department, all are entitled to 300 days. As per notification dated 3/3/2012. And this notification was issued, my lord, in terms of the order passed by this honorable court dated 2/6/2011 in WBC 9851. My lord, relevant para 33, para 33. Page 41, para 33, my lord, relevant. This honorable high court order, my lord. Then after this or judgment and order, my lord, passed by this honorable court, my lord, authority, respondent authority, my lord, has issued this notification office memorandum dated 3/3/2012.
Which is the relevant part in 3.3?
My lord,
Relevant portion in 3/3/2012 notification
of the judgment, my lord.
or not office memorandum,
Office memorandum, my lord, page 42 to 45.
which is the relevant part?
I'm showing, my lord. Well, type to be, this is my one, page 42, my lord. Serial number 1, my lord.
Please read.
Consequent upon the withdrawal, my lord, may I read the above para? In
Hmm.
pursuance of Honorable Guwahati High Court judgment and order dated 2/6/2011, passed in WBC number so and so, and in compliance of the order, the Governor of Assam is pleased to withdraw the Finance Department's office memorandum dated by these two, my lord, by which our days were curtailed, my lord. To leave salary for the employees of Vacation Department with effect from the date of issuance of those office memorandums. Number one, consequent upon the withdrawal of the above mentioned two office memorandums of Finance Department, the benefit of unutilized leave encashment at the credit on the date of retirement on superannuation will be admissible to the employees of the Vacation Department to the extent of permissible days as in force at the relevant period of for the employees of the non-vacation department.
Yes, miss, what do you say?
Your lordship may issue notice, lordship. We will verify if they are embezzled. It will be announced.
Your lordship may be pleased to dispose of in the terms of the order passed by this honorable court. They will verify, my lord. If I am entitled, they will get.
Lordship may issue notice. We will verify.
You want
lordship.
notice?
Yes, lordship.
My lord, I want
We'll
because this is
verify.
their retired people, my lord. If they are aggrieved again, they have to come. Therefore, my lord, the order may kindly be passed, my lord, disposing of the matter, directing them to verify. If I am entitled, then they will give. And my lord, it is a covered case. This honorable High Court passed order, my lord, like that, my lord. Verification part is open to them.
What have you done after getting that amount? Have you not submitted any representation?
We approached, my lord, repeatedly approached, my lord.
Where is that?
And matter is settled, not in writing, my lord.
Then
We approached, my lord.
you should have approached. You have not approached.
We have given, my lord, in paragraph 15, my lord.
We
If
don't
they-
know. We don't know. It's making statements only. So you should have written one letter that I should get 300 days.
And they had, my lord, issued also, my lord, because this is settled matter. They have issued their notification. This honorable High Court passed this judgment and order.
Is
my
right.
lord.
The petitioners who are retired school teachers are aggrieved in not being given leave encashment for 300 days, which is permissible in terms of office memorandum dated 1/9/2000 bracket annexure 2. And office memorandum dated 3/3/2012 bracket annexure 6. Start Mr.
AFNU.
AFNU Mola Learned Counsel for the petitioner. Issue notice of motion returnable by 3 weeks. Miss
NM Sharma, lordship.
NM Sharma, Learned Standing Counsel,
Secondary.
Secondary Education, accepts notice on behalf of respondent. Numbers
1, 2, and 4,
1, 2, and 4.
lordship. Papers.
Miss RM Barwal, Learned Standing Counsel, Finance. Accepts notice on behalf of respondent number 3. Notice is therefore complete. Petitioners to furnish requisite copies of the writ petition to the Learned Counsel appearing for the respondents today within 2 days. Establish the matter again after 3 weeks on a date to be fixed by the registry. Stop the counsel for the respondents shall obtain instructions so that the matter can be taken up for disposal on the next date.
But pendency may not be barred to.
Pendency shall also not be a bar for the respondents to mitigate the grievance of the petition.
Obliged. Maybe.
Yes.
My lord, the petitioner, your lordship is an assistant teacher of high school.
Good.
And on 18/4/2023 and 19/4/2023, she could not attend the school on account of her illness, my lord.
Hmm.
And the very next day on 24/2023, appeared in the school and submitted, my lord, CL application. My lord, and she was also entitled to for the CL facility that during that period of time. But that application has not been considered. Then shock of notice was issued. And she also replied to that shock of notice. And thereafter, my lord, this Annexure 9 order dated 5/7.
Pay cut.
Pay cut.
How many days?
The 2 days pay cut. My lord.
2 days pay cut.
And two similar matters were moved day before yesterday, before your lordship.
Yes, what was the order passed?
My lord, yes, sir. Notice was issued,
Will issue notice?
my lord. Exactly similar matter, same school, by same communication, 2 days salary have been cut from the salary.
Notice may go in his.
Today, who has come? What is the name? Amina, Amina.
Yeah.
Amina. Amina Sultana Bawiya.
Over here. And earlier there
Okay,
was,
serial number 1.
my lord,
Earlier, who had come? Earlier was
Moumita Pal,
Amita Paul,
and another,
serial number 2.
another Devasida.
Okay,
Similarly, notice may kindly be issued, my lord, at this stage.
heard Mr. A.R. Talukdar, learned counsel for the petitioner, who submits that the petitioner, who is working as a graduate teacher in Rangpur High School, Silchar, Kachar,
Assistant teacher, my lord.
assistant teacher, was working as assistant teacher in Rangpur High School, Silchar, Kachar, is agreed with the deduction of her 2 days salary. So the learned counsel submits that the petitioner could not attend school
On 18/4 and 19/4/2023.
on 18/4/2023 and 19/4/2023 on account of her ill health.
Illness.
So accordingly, she had informed the headmaster about her condition and thereafter submitted casual leave application on joining the school. Stop, however, the same was not accepted and instead write communication dated 5/7/2023, bracket Annexure 9. Her 2 days salary was deducted. Next para. In the same para, stop agreed, the petition is before this court. Next para, issue notice of motion returnable by 4 weeks.
Hard copy was one I did not.
Ms. P. Das, learned standing counsel, secondary education. Accepts notice on behalf of respondent numbers 1, 2, and 3. While Ms. S. Quar, learned government advocate, accepts notice on behalf of respondent number 4. Notice is therefore complete. Petitioner has to serve requisite extra copies of the petition to the learned counsel appearing for the respondents within 2 days. And petitioner to take steps for service of notice upon respondent numbers 5 and 6 by registered post with a review within 3 days. This is the matter again after 4 weeks, along with WPC number 43. I'm sorry, along with WPC number 4338 of 2025 on a date to be fixed by the registry.
And another petition is also there, my lord, which was also moved day before yesterday. I am giving them. Four.
Huh?
Four.
So,
I'm giving the number, my lord.
Give the number
Am I-
and also one number, one more writ petition is there. You take the number.
Yes, ma'am.
You
Oh,
give-
bless me. I'm giving-
And this is second round of litigation, my lord.
Okay, what,
Earlier occasion, lordship Petitioner, my lord, actually, my lord,
Where's the order? First round?
first one, my lord, yes, lordship will get his annexure 10 at page 58, it is started, and 11%, my lord.
58.
Yes, my lord.
Hmm.
Whereby certain, my lord, gross irregularity regarding, my lord, the allotment of numbers under the category of the, my lord, the teaching experience in respect of the college teachers appointment. And another for my extracurricular is a 1 mark.
Hmm.
That was, my lord, illegally allotted to the respondent number 6, by which, my lord, she was recommended as the first nominee, by, my lord, relegating me as the, my lord, second one. So, my lord, on that matter, I have filed 3 representation before the director. And when nothing was there, then I approached before the lordship. And as the matter was not attained to finality, there is no recommendation or cancellation. The lordship has given a direction to the authority concerned to the director specifically. And the lordship will come to straight in page 6 of the para 5.
Page?
Yes, my lord.
Page
My-
number?
My lord. Page number 60, my lord. Yes. By which, my lord, lordship has given on perusing of the order dated 7/12/2020 passed in WPC number 1 such and such fact of the case. The fact are equally quite similar. In this clear that no final appointment order has been issued by the director, thereby implying that the selection process has not been attained finality as on date, as Rule 7 of the Assam College Employees Provincial Regulation 2010 provides that the only appointment shall be made by the director on the basis of the recommendation of the governing body based on the recommendation of the selection committee. The director, Higher Education Department is directed to take a decision on the petitioner representation dated 5/3/2025, 8/3/2025, and 10/3/2025, while considering the recommendation of the selection of the respondent number 6 by the selection committee and governing body. My lord.
So
But-
decision has been taken and director has decided to go ahead afresh.
Yes, my lord.
So that is why you
That
agree.
is, my lord. But that cannot be, my lord, because the director, my lord, as per the rule 7, my lord, the straightway he cannot cancel, but there is no illegality, gross illegality to interfere with this in a press election.
Okay, we'll issue notice.
My lord, but my present is, my lord, the notification that we state, my lord.
What do you say?
No, my lord, it is we say, otherwise, my lord, that will be, my lord, one thing, my lord, let me complete. I have no objection, my lord, if the fresh election is done, that to be, my lord, among the same candidate, by the same panel, my lord. Because, my lord, my age is there, I have spent a lot of time in this election. If I, my lord, going to a fresh election, I may not be selected, my lord. So there is no any gross irregularity to say that my lord, there is some irregularity, so that is why the result is given.
Some irregularity was there in respect of the.
Regarding.
No, please listen, please listen.
Yes, ma'am.
You are getting very excited.
No, no.
See, there is some irregularity regarding the private respondent. Some marks was allotted,
Yes,
which he or she should not have got.
yes.
So this was discovered later on. So director saying that,
No,
okay, because of this, let us go for a fresh one.
no.
And according to you, if marks was given, which that candidate did not deserve, then marks should be deducted.
Yes, my
And
lord.
according to the next
That is the
candidate,
procedure, that is the follow.
and accordingly, the next candidate
Yes, my lord.
should get the chance
Yes, my
to be
lord.
appointed.
Yes, my lord. That is the procedure.
this is
they have
what you
followed
want.
since long, my lord.
This is what you want. That's why you want a stay of the speaking order.
Yes, my lord. Because, my lord, suppose, my lord, if you go for the phrase advertisement, it is also one important thing, my lord.
I've understood your
Yes,
problem.
my lord, one thing, my lord. From this order, it is also not clear whether, my lord, they are going for the phrase advertisement, anything, my lord. It is only saying that this phrase selection. My lord,
So, yeah, you take
Lordship,
instructions.
Lordship, I'm going by my,
You take instructions.
going by submission of a plain lordship. There is a gross illegality. But one thing that in the rules also, in the rules, there is no, the thing, one candidate is recommended lordship. In the rules, nowhere there is second candidate for appointment lordship. I suggest lordship, it is notice and we file affidavit, dispose short time lordship. I could not place
Short
the,
time. Meanwhile, don't go ahead with that advertisement.
no lordship. That I could not, at present, I have no order, there's some.
Meanwhile, status quo.
Yes,
No,
my
That
lord.
will- that will be there.
Yes, my
But then I,
You take your instructions as quickly as possible.
Yes, my lord.
lordship,
We'll
one thing,
dispose it off,
lordship, one thing that.
but
there's no-
status quo.
No process is initiated till, no, see.
We don't know.
No, nothing, no, lordship, no interim lordship. 10 days time, I'm taking instruction lordship.
Even
Otherwise, that will be notice will issue, file affidavit, that will do it lordship.
My lord, as
I
per
have,
the,
I have the judgment
as per the-
regarding case, the lordship.
as per the, my lord, procedure, my lord. If something is happening wrong, in earlier occasion also lots of incidents are there, my lord. They have to send back for revalidating, not to cancel, my lord, on the basis of the purely, my lord, following the guidelines. So as there was no violation of the guidelines, that is why, my lord, this director came to the conclusion that 1 mark in case of the, my lord, the extracurricular activities, and 0.5 mark that was given to the teaching employee, that was not entitled to the respondent number 6. So does not mean that the entire selection is bad, my lord. So that was done at the behest of the selection committee member. It is lordship, my lord. I will show you lordship, all the individuals.
Marks given was 0.5.
Yes, 0.1.
0.5 marks
For
under teaching experience
teaching, yes. She
and
got
1 mark for
extracurricular.
extracurricular.
There was also no document to support him.
She had gone for Olympic or something.
Yes,
Huh?
my lord, there is no such document, my lord.
Which discipline?
Yes, my lord.
That we don't know.
No, my lord.
Okay.
That director also not see, my lord. And moreover, my lord, my instruction is this: she got, my lord, the gold medal in the masters. So, in respect of receiving the gold medal, 1 mark was added. She is not entitled on that because the marks, my lord, whatever get by the all the candidates in their master degree, as per their marks secured, the my lord, selection committee recommended the marks. So whenever, my lord, she got the marks on the basis of her marks, marks secured in the MA.
Okay,
so
let me-
double benefit cannot be given.
Let me pass the order. I heard Mr. P. Mahanta, learned counsel for the petitioner, who submits that this is the second time the petition is before this court. To stop the earlier writ petition being WPC number 1712 of 2025 was disposed of by order dated 28/3/2025 by directing the Director Higher Education Department to consider and take a decision on the 3 representations submitted by the petitioner on 5/3/2025, 8/3/2025, and 10/3/2025. Next para. It is the case of the petitioner that petitioner is she,
Petitioner, my lord.
he,
He.
and private respondent,
She.
petitioner, that he took part in the selection process for filling up of the philosophy bracket 19 unreserved close bracket at Puthimari College, Soneshwar, Kamrup, Assam. Stop. While he was expecting to be selected, the private respondent number
6.
6 recommended instead to stop the petitioner being aggrieved with the grant of 1.5 marks to the respondent number 6 submitted his representations. And since the same was not considered, he approached this court through the first writ petition. Now, when the first writ petition was disposed of in the above manner, the Director of Higher Education passed the speaking order dated 9/7/2025, whereby the 1.5 marks allotted to the respondent number 6 was found to be unwarranted. Stop. Instead of recalculating the, instead of reassessing the marks received by the candidates, the director took a decision to go for fresh selection. Stop agreed, the petition is before this court. Next para, Mr. P. Mahanta, learned counsel submits that if there was some irregularity in grant of 1.5 marks to the private respondent number 6, a reassessment could have been done by the respondent authorities. And the same does not call for cancelling the entire selection process. Stop. The learned counsel therefore submits that appropriate direction should be issued to the responding authorities, and pending disposal of the writ petition, the speaking order dated 9/7/2025 should be stayed. Next para, in view of above, issue notice of motion returnable by 3 weeks. Mr. S. Bhuya, learned standing counsel, higher education, accepts notice on behalf of respondent numbers 1 and 2. Petitioner to take steps for service of notice upon the remaining respondents by registered post with due within 3 days. Petitioner to furnish requisite extra copies of the writ petition to Mr. S. Bhuya within 2 days. Next para, having regard to the projection made by the petitioner, it is hereby provided that status quo as on today shall be maintained till the next returnable date.
Lots of.
My lord, I want to show one thing. Lordship, may I
Yes,
have a look at page 51, and how I have been deprived. Lordship from this.
we'll consider, examine that.
0.21 marks I have been making difference, my lord.
Lordship.
Why illegal?
Mr. Bhuya, what?
Can my assumption that the rule does not provide for the rule does not provide. Rule does not provide to recommend second person loss.
Where from to say, I don't understand.
This is my submission.
It is nowhere it is settled, my lord. Only
The-
recommendation, my lord.
I'm,
Okay,
So
right,
my
like this,
submission also.
right, Mr. S. Bhuya, learned standing counsel submits that the rule does not provide,
there is no waiting list also.
The waiting is I am not concerned.
does not provide for
I am
for
not-
considering the second person in line.
Yes, Lordship. This is my submission.
Okay.
And
Be that as it may, the same will be considered at the appropriate
then,
time.
then apart, the college does is still not for fresh, then non go for fresh selection loss.
It's okay, see,
That's
you
a
take instructions and you file an affidavit,
loss.
and if you file it, we can
Yes.
make an attempt to
Yes,
dispose it
yes,
of next
definitely
week.
loss. And that, in this, I
Rule
find,
7, Rule 7 itself saying, it is
Some-
only for recommendation,
some,
my lord.
some
It's
lots
not
of,
saying that a
I
one
cannot
or
say-
two, my lord. It
some
recommends
judgment is there,
that
Lord.
again.
I like.
If something
I
is
prefer
wrong,
the judgment loss.
thank you, my lord. Lordship, I will read the
Yes.
judgment of the Honorable High Court, where it is saying the director cannot do as the staff, my lord, our staff. They have to utilize their own mind and other things. my lord.
And I'll let it even place the judgment also.
Good, we'll have good arguments next time, okay? You
Really
prepare.
obliged, Lord.
Yes, for last order lordship, they were provided an opportunity to plead their case lordship, otherwise appropriate orders will follow.
In this matter, the director has written to the inspector of school regarding the attendance register and other records of the petitioner. So can be some time to verify all this thing.
No, just a minute, let us see what is the direction. Operative portion.
Lordship is having.
Is it page 37?
Lordship,
Paragraph 19?
paragraph 19, lordship. Taking into account the same, this to prepare for disposal of the instant batch of writ petition with a direction to the concerned respondent authorities, more particular Director of Secondary Education Department, to consider the case of the petitioner for provincialization of the services as teachers and or tutors by making necessary verification in terms of Section 4 of the Act of 2017 and without insisting upon their names being captured in the Dice Code of 2009 to 10 or prior thereto. This exercise be completed within 6 months on the date a certified copy of the judgment is served upon the Director of Secondary Education Department.
So what steps have you taken? Mr. Yusha?
Yes. My lord, here the director has written to the inspector of his school regarding the
when?
collection of the attendance register of the teaching staff. My lord.
When did he write?
My lord,
Date.
5/8/2025.
Sorry,
Yes.
what is the date?
Yes. That is not mentioned here, my lord. Yes,
How can it be? Director is supposed to give date. If director doesn't give date, who will give date?
My lord, this instruction come on 5/8/2025, but it is written earlier, my lord. The undersigned has instructed the concerned inspector of school to collect the attendance register of the teaching staff of Dagna Senior Secondary School, South Salmara, Mankasar for the period of 2019 to 23-24 to ascertain the presence of petitioner as per mandate of Section 423 of Assam Education Provincialization of the Services of Teachers or and Reorganization Education Institution Act 2017.
So Lordship, both these letters, one in the case of item number 15
And
is signed on 5th of August. Digitally signed on 5th of August, Lordship, and in the case of item number 15, signed on 1st of August.
Mr. Sharma,
Yes.
judgment was passed on 12/4/2023. When did you start waking up? I mean, the director, not you, the director.
Regarding that, my lord, I have to take instruction, man.
We will ask him to come here.
We have not.
We will ask him to come here.
No.
What kind of instruction is that? Hmm?
My lord, here actually.
Is it your case that you have not received a copy of the court's order?
Lordship, we, representation is at page number 39. Your
Mr.
Lordship.
Counsel, you take a back seat now, okay?
Lordship, Lordship,
Don't aggravate the things.
Lordship.
See, order passed in 2023, copy furnished to you in 2023. And today you say that we are asking for the attendance. That shows that they are taking the court for a ride. Hmm?
Some more time may be granted so that.
On what ground should we grant you? Tell me.
Well, my lord, here to verify all these things, the inspector, the director has a call to the inspector regarding the instruction.
More than 2 years have gone now. How long will you take? Is it coming from instructions coming from the other end of the world? Hmm? When does that instruction given to you?
5 August 2025.
5th August.
Yes.
Court had passed the order on 19/6. Still, even that within that also there's still delay. You did not communicate the court's order of 19/6.
I have communicated it.
When did you communicate? After 2 months, they're communicating back to you. Okay, please write. There was the last court's order dated. No, you write like this. Your good name?
And Gautam, Lordship.
Mr. N. Gautam, learned counsel appears for the petitioner, and Mr. U. Sharma, learned counsel appears for the sole respondent. Stop peruse the last court's order dated 19/6/2025. To stop. Today, Mr. U. Sharma, learned counsel, submits that as per the instructions received by him, by letter dated
5/8/2020.
5/8/2025 from the director of Secondary Education. The state authority has called for the attendance of the sole petitioner over
Full petitioner.
of the petitioner for the year
2009-10 to 2023-24.
2009-10 and 2023-24.
2009-10 to 2023-24. 9-10 to continuously 2023-24.
Okay, 2009-10
To
to TO2, 2023-24. Which is in furtherance of the compliance of the court's judgment and order dated 12/4/2023. To stop, it is however seen that the judgment and order of this court was passed more than 2 years back, and a copy of the order was furnished to the Director of Secondary Education.
3rd of May 23 election. At the bottom lot.
There are two dates for 3rd or 4th.
Lordship, 3/5/2023 lordship.
Then what is this 4/5?
That's probably a reference number, your lordship. 3/5.
Which was furnished on 3rd/4th of May 2023. To stop, it is not understood as to why the director has only sought for the attendance information at this belated stage. To stop, under the circumstance, this court hesitantly grants 3 weeks' time to the respondent to file show cause reply, clearly indicating all the details of the steps taken pursuant to the order passed, pursuant to the judgment and order dated 12/4/2023. In WPC number 1353 of 2022. Failing which, the director shall have to appear before this court.
Lordship, this judgment in this particular case, the petitioner's case number was 7026 of 2021.
Okay,
It was a common judgment and all.
all right, change the number 7026
26 of 2021.
of 2021. This is the matter again on so and so. Give a date, please. 28/2025.
Lordship, another with regard to item number 15, Lordship. The WPC number 7028 of 2021, similar case, Lordship.
Which one?
Item number 15, your Lordship.
Now let it be called.
Lordship.
You are in a hurry.
Lordship.
This is also same thing.
Lordship.
And what is the case number here?
7028 of 2021.
Yeah, please write that. 77028
28 of 2021.
of 2021. Similar order.
And the representation is dated 2/5/2023.
My lord, in this matter, director has written to the Department of School Education for instruction, my lord, for their instruction.
Okay. Director has written, has
Yes.
called for the, we had written, the director had called for the attendance. Instead, out here, right, director has written to the,
Government, secretary to the government of Assam,
has written to the secretary, the government of Assam,
for necessary instruction, for their.
which department?
Secondary school education.
Secondary school education. For necessary instructions on,
Here, date has not been mentioned.
okay,
25/5/2024, man.
25/5/2024.
Yes.
Okay. Earlier was attendance, this will be instructions from government. That is the difference only. And case number, you've got it. Others all similar.
My lord, my lord, there is 1/8/2025. This letter is written to the secretary to the government, school education department,
Okay. Letter dated 1/8/2025.
2025.
Yes. 16?
Here last chance was given.
Yes, PK Bora Lordship, he will apply this because he is on the way, Lordship. Lordship, you can take that as the last item, Lordship.
Okay,
Yes, just after 19.
time being.
Can we see the last order?
Mr. B. Kaushik?
Malad. So it was placed on 20th of June, Malad.
Yes, that was what you said last time.
Yes, yes. Malad, we are still awaiting the outcome of the, Malad, the meeting.
When will you get the outcome?
Lordship will give us 2 weeks time, Malad.
28/6, something happened. You're not aware about that?
No, Malad. Now, as per my instruction, Malad, it was placed, Malad, on 20th. It should be 2006, Malad. Not 20,
Not 28,
2006.
20.
20.
Mr. B. Kaushik, Learned Counsel for the respondent number 1, subject that the issue of provincialization of the school concerned was
Petitioner.
scheduled.
The petitioner.
Only petition on it.
Okay, provincialization of the petitioner
Yes.
was scheduled to be
Was placed before the joint committee.
considered on 26/2025. But he submits that he is yet to receive instructions in this regard, and therefore prays for 2 weeks' time. Prayers allowed, list again after 2 weeks.
Can it be fixed on that? And looking at the.
Give a date after 2 weeks,
Yes, sir.
on 27/8.
Here, your lordship. Order is dated, your lordship. On 6/6, there is a hearing took place, your lordship.
Yes, 6/6. Yes,
Lordship.
Well, I submitted the instruction. Malad.
what is this?
Well, in the hearing, Malad, it came out, Malad, that the petitioner on the day on 1/19/2025, Malad, was 59 years.
So what was the decision taken?
Malad, perhaps, Malad, in view of that, Malad, because the petitioner, when has instituted the writ petitioner, projected that she is entitled to be an headmistress of the high school. However, Malad, the school was upgraded much prior before the order was passed, Malad, to the higher secondary. So the post of headmaster is no more there. It is a principal. And for the purpose of principal, Malad, the qualification which is required, Malad, there is a criteria that the candidate must not be above 57 years on the date when the post fell. So on that day, well, therefore, this aspect was never brought to the notice of.
Lordship will kindly see, your lordship. Your lordship may kindly see the order, your lordship. In that case, your lordship, in the writ petition, they have never placed this fact, your
Well,
lordship.
that is what
And
my
in fact,
instruction
your
said.
lordship will kindly note, your lordship, these are all the tactics, your lordship, just to avoid the, your lordship, appointment of the present petitioner, your lordship, as an in-charge headmistress, your lordship. The appointment that they have been made, your lordship, as an headmistress in charge, your lordship, the earlier incumbent, your lordship. If that be the case, your lordship, why had they appointed here the other incumbent as a headmistress in charge, your lordship? It is the post of principal, your lordship. Your
So-
lordship will kindly see the
okay.
order, your lordship, at
Anyway.
page 10.
Let him file the instructions. We'll see.
No, your lordship will kindly see.
We'll ask him
Please,
to
Your
file the
Lordship.
instructions. Mr.
I
P.
have, your
Kaushik,
lordship, 3 months to go, your lordship, for retirement. This
Mr.
is the order, your lordship, dated 21/6/2024, your lordship. For 1 year, your lordship, they sit over the matter. Even after filing of the contempt, they have given least respect to this, so this respect to this honorable court, your lordship.
Okay, so I'm asking him to file it.
Within
Mr.
Lordship, a week.
Mr. B. Kaushik, learned counsel for
Definitely,
the
Your Lordship.
respondent.
I have
submits
3
that
months to go, Your
He
Lordship.
has received the instructions. And may be given 2 weeks' time to file the show cause reply, to file the instructions received by him. To stop considering the fact that according to the petitioner, he or she,
See, Your Lordship.
she is in the verge of superannuation. A week's time is granted.
Can it be 10 days?
Your Lordship may fix a date, Your Lordship, in that event, Your Lordship.
Okay, 10 days time is granted to the respondent to file the affidavit. List this matter again on sense.
Highly grateful.
Lordship.
18.8.
Obliged.
Deeply obliged. Restriction of copy to the Evan.
Yeah, please, Your Lordship.
Yes.
As for last order, Your Lordship's order dated 28/7/25, my lord, instruction was sought for.
Yes, and I think this is again. The jury was
Yes.
there. Yes.
They have again revert back the proposal to the inspector of school. That is what my friend has told me, Lordship, right now. So we have submitted the proposal. They have made some queries. Then again, we made those queries and submitted again to the director of pension. Now, Lordship, on 17/7, they have again sent the proposal to the inspector of school to fill up a particular pro forma, the slip. So again, we have to do that, Lordship. Thank you.
You have received written instruction.
He has received.
You have received written instruction.
Yes.
You file it. I'll give you a week's time.
Yeah. They will do the next.
The instruction which you have received that traveling from A to B, B to A, like that.
Lordship, what it is that, they need to duly filled in a pro forma, which has also been furnished to them. It is this. Your Lordship.
So
Could I-
what I'm asking you is to explain that in your affidavit. You file an affidavit saying that oh, this is the process which is we are doing.
Yes, ma'am.
We'll consider. Was today what you submit, next day we'll forget also again what you submitted. Again, you have to repeat. But if you give it in writing, that'll be better. Mr. B. Deori, praise for and is granted a week's time to file the instructions received by him. List the matter again on so and so.
But to humbly your Lordship, I think the matter will expedite if in the department, your Lordship, there has been sent to inspector of school. If they come with the complaints of this, submit the performance.
That will go on.
Because my submitted.
We're not stopping the compliance. Let them comply. But as of today, what steps you have taken, put it in writing. We'll see.
If this be, if I'm furnishing this to. this
No,
may be
I'm
on
not.
record.
No.
This may be on record.
We annex that in the, we'll take it on record, not like that. Otherwise, loose paper, so many loose paper, we don't know. Next day, some other bench will see, they'll know, see what is this loose paper. So that's why you file an affidavit, short affidavit saying that this is what we have done.
May I pay for a fixed date, madam? 21
Same date,
of these others, 21.
we'll give a same date. What is the same date? 18. By 18 you file.
Obliged, ma'am.
Well, here I need some time. I have not. received any
I
instruction.
spoke,
Only
my
thing
lord,
that
kindly
I'll-
peruse the last.
Here
one.
will
Only the
direct-
personal appearance, he will not do anything.
Let him submit.
Here, director has asked the secretary to provide some specific instruction. That is why, my lord, we have not passed any specific order, my lord.
My lord, direction is to the director, not
True, my
to the
lord, that is
secretary.
true. But some instruction is required from the secretary.
Not necessary.
But this is.
Paragraph
internal-
12, my lord.
Internal, my lord, communication.
Page 20.
Please let me read myself.
Fine.
Both of you don't submit now. Now, where is the order to be complied with?
My lord, page
20.
15, page 15, paragraph 20, paragraph 12, page 20.
State level, please read.
My lord, the state level scrutiny committee, upon consideration of the case of the petitioner in the light of the recommendations made by the district scrutiny committee, so and so proceed to recommend the case of the
This is the Director of Elementary Education Assam shall take appropriate steps for implementing such recommendations and provincialize the service of the petitioner with effect from 1/1/2021 with all consequential benefits of pay, seniority, etc. In the event, the state level scrutiny committee finds that the case of the petitioner cannot be recommended for provincialization of his service, the Director of Elementary Education shall issue a speaking order incorporating reasons as to why service of the petitioner was not liable to be provincialized and communicate to the petitioner. They
Okay.
communicate the same to the petitioner. Nothing has been done.
Okay, so this is the order passed on 9/2/2024. Mr. Bora,
My lord,
what is the difficulty?
difficulty is that, my lord, here director has seeking some clarification from the secretary, my lord. Only thing is that is why, my lord.
When did he seek clarification?
My lord. That was communicated,
Recently?
my lord.
So all this time, what was happening then?
One last chance, my
Huh?
lord.
No, all these days, what was happening?
No, that is,
Copy was given to you? Punished to you or not?
that's,
Page 22 is the forwarding letter, is it?
no.
My lord, I furnished on 19/2/2024.
So more than 1 year now,
So, my lord.
1.5 years now.
1 year.
So still communication is going on.
No, my lord, yeah, nothing, nothing. has
No,
been-
he said he's seeking clarification.
What is this? My lord may finally perish what is the clarification seeking letter. I think no
I
letter.
have that, my lord.
Hmm?
I have that. My lord, last chance may be given if we will.
Last
fail
chance for what?
to produce the, my lord, order.
Produce?
The speaking order or whatever else the authority do regarding compliance of the order, my lord.
Failing which, he will come, director will come here
My-
and explain.
My lord already given last chance, last order kindly tell us, my lord. 25/7.
Although last chance was given to the respondent to come up with positive compliance of the court's direction. Mr. P.K. Bora Lanet, counsel for the
Sole respondent.
sole respondent, that is, what is the respondent? Director?
Director Elementary Education.
Elementary Education. Submits that he may be given one more chance. Since some instruction is being sought for from the administrative department. To stop, it is however seen that the order of this court is dated 9/2/2024. And a copy of the same has been furnished to the director on 19/2/2024. How you served? By
But,
post,
By post.
by post. So when did he receive? We don't know.
No, my lord, by hand, my lord, by hand, but receipt is not given
Then,
by. But
We have received,
sometimes
my lord.
they have received. They did not.
no, he has admitted that they have received, but you should also get acknowledgement, isn't it?
Sometimes not given, my lord, the in office also.
It is not understood why the order of this court has not been complied with. Even after a lapse of 1.5 years since then. Full stop. Under this circumstance, the respondent shall file an affidavit indicating all the steps taken pursuant to the order of this court dated 9/2/2024 within a period of 2 weeks
My lord.
from today. Failing which, the director will have to appear before this court personally. List again on so and so.
Obliged, my lord.
28.
I am.
my lord, can it be on Friday, my lord? 22, my lord.
Which case?
Well, this case, my lord, this content.
I said 28. You want shorter time?
No, my lord, no. So I put 20. No.
There's some urgency on his part.
Now urgency is coming.
No, we don't have anything against them. Only thing is that when